Now, I am going to dictate a legal passage at the rate of 160 words per minute. 5, 4, 3, 2, 1, start.
Let's start. The civil judge exercising jurisdiction under Section 7 of the 1997 Act does not have the jurisdiction to entertain any application for extension of time to deposit the amount adjudicated by the original order passed under subsection 7 within bracket 2 after expiry of the period stipulated by the original order para. A close scrutiny of Section 7 of the West Bengal Premises Tenancy Act 1997 would reveal that there is nothing in the section providing extension of time or condonation of a default. Of course, under the proviso to subsection 2 of Section 7, the court is vested with power to allow an extension of time only once, and the period of such extension shall not exceed 2 months. Thus, the time limit specified in clauses B and C of subsection within bracket 1 as well as in subsection within bracket 2 and the provision to the said subsection are conclusive and mandatory. Such time limits cannot be extended or delay in default cannot be condoned. Para. In our view, even availability of accommodation in the flat held by the landlord's son cannot be regarded as an alternative suitable accommodation for the plaintiff, as the plaintiff cannot be compelled to move to his son's flat when he has his own flat in the shoot house. Para. The periods in the plaint filed by the appellant indicate that the appellant is seeking a declaration of his title vis-a-vis the shoot property. Such a declaration can obviously not be granted by the controller, who is only empowered to ascertain which part of the premises are tenanted and which part is in occupation of the sub-tenant. Para. None of these judgments have laid down the contrary proposition so far as the power of the appellate court to direct the appellant to pay the higher amount as occupational charges for enjoying an order of stay of the execution proceeding pending the appeal. The quantum of occupational charges is not static but depends upon the various factors which could be reasonably ascertained from the aforesaid decisions, though the appellate court is within its power and jurisdiction to direct the appellant to pay the occupational charges at the prevalent market rate, but at the same time the court should not arbitrarily fix the quantum which in other way operate harshly upon the appellant, and the order appears to be punitive and in terrorism in absence of any material before the appellate court on the prevalent market rate. The appellate court can apply robust common sense, the common knowledge of human affairs and events gained by the judicial experience and judicially noticeable facts. As such, the tenancy of the subtenant under his landlord comes to an end with the passing of the eviction decree against him. As such, the said benefit which was extended only to the existing subtenant who is in position as subtenant in the portion laid out to him cannot be extended to the petitioner after passing of an eviction decree against him. Para. The landlord or the dispossessed tenant can, in such circumstances and by virtue of the locus recognized in the relevant expression, be entitled to recover possession from the trespasser who has forcibly dispossessed the tenant otherwise than in due course of law. Para. In my view, Section 44 of the 1997 Act should be read to mean that a civil court shall not have the jurisdiction to entertain an original or independent suit or proceeding by the tenant for effecting repairs to the premises in question. However, if a civil suit is already pending between the landlord and the tenant, it is the civil court is cessation of that suit which alone will have jurisdiction in the matter of repairs to the premises. Para. The law on the issue can be summarized to the effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation in case a party is found to be negligent or for what of bona fide on his part in the facts and circumstances of the case are found to to have not acted diligently or remained inactive there cannot be a justified ground to condone the delay. No court could be justified in condoning such an inordinate delay by imposing any condition whatsoever. The application is to be decided only within the parameters laid down by this court in regard to the condonation of delay in case there was no sufficient cause to prevent a litigant to approach the court on time. Condoning the delay without any justification, putting any condition whatsoever amounts to passing an order in violation of the statutory provisions, and it tantamounts to showing under disregard to the legislation parent. From the bare reading of section 83 within bracket 1 and section 85 of the Work Act 2013, it is crystal clear that nowhere it is mentioned that the civil court jurisdiction has been waived, excluded, or barred by those sections. In my considered view, if it is an ejectment of the eviction suit of the work property and no dispute raised which are specified in section 6 and 7 of the Act, then the suit for eviction against the tenant relating to a work property is very much within the domain of a civil court and not within the jurisdiction of work tribunal. Stop. Thank you. Jai Hind, Jai Mera Bharat.